Good afternoon. Thank you for being here this afternoon. I'm Minority Leader Lisa Damuth. And today we are going to hear on the floor a bill that puts kids at risk and undermines parental rights. There's several concerning parts to this bill that we're going to be hearing. Parts of this Democrat transgender healthcare sanctuary state bill that we're going to be hearing. I'm going to let a couple of my colleagues get into some of the specifics, but I want to just highlight how misguided this truly is. And one thing is clear, the Democrat priorities are completely at odds with Minnesotans' priorities. Democrats are going to tell you that this is what Minnesota voted for, but it is not. The vast majority of parents in Minnesota do not put these issues as a top concern for their children. Focusing on school safety, focusing on our kids' education, focusing on safety within our community, that's what helps all students and all kids in Minnesota. Today is actually about protecting our children. And House Republicans today are going to stand up for the majority of Minnesotans that want to do the right thing and protect our kids. With that, I'm going to turn it over to Representative Peggy Scott.
Good afternoon. As Leader Damuth said that today, House Republicans are taking a stand to protect Minnesota's kids. House File 146 undermines parental rights and, most concerningly, has zero guardrails to protect our kids. As a Republican lead on the Judiciary Committee, I have been working with our team on this issue, and we have identified numerous concerns with the bill. The bill makes Minnesota a sanctuary state for so-called gender-affirming care, while simultaneously infringing on the fundamental right of parenting. It allows children, regardless of age, to seek and receive radical medical treatments that can cause sterilization, bone loss, loss of sexual function, and interference with brain development, all without their parents' guidance and love. Our own Mayo Clinic and the NIH have stated the risks involved with hormone treatments, especially pre-puberty. These treatments can be dangerous and permanent. This bill denies that science. This bill undermines parental rights. The Supreme Court of the United States has declared that in the 14th Amendment of the Constitution that it protects the rights of the fundamental right of parents to direct the care, upbringing, and education of their children. This bill would also allow a child predator or other person to lure a child into getting gender-affirming care. The bill says no criminal or civil penalty can be brought against a person, whoever that might be, for allowing or providing gender-affirming care. No parent needed. We used to protect our kids in the state of Minnesota. Further, this bill allows for an initial custody jurisdiction hearing to determine custody of a child in this state just by virtue of them being in the state of Minnesota for the purpose of obtaining gender-affirming care. It allows for the temporary emergency jurisdiction of one of the determining factors to be whether the child has been unable to obtain gender-affirming care. This means if a parent believes this treatment is not best for their child, a court can have an emergency hearing to remove the child. These parents would be on the same category as someone who has neglected or abused a child. I would like to turn it over to a member of our Judiciary Committee, Representative Harry Niska, for some legal comments.
Thank you, Representative Scott. My name is Harry Niska. I'm an attorney. I'm a member of the House Judiciary Committee, and I'm honored to represent District 31A in Anoka County. as Representative Scott indicated, there are a lot of concerning legal aspects of this bill. In particular, there's a looming significant constitutional problem in this bill. This bill is a direct assault on the full faith and credit clause of our U.S. Constitution, which is the provision that says we as the state of Minnesota or any other state is going to honor the legal judgments that are entered in every state in the nation. This bill directly contradicts that and tries to violate that by saying that certain custody orders are not going to be honored in the state of Minnesota. The late Justice Ruth Bader Ginsburg in a 1998 majority opinion for the U.S. Supreme Court said that the animating purpose of the full faith and credit clause is to make all of the different states integral parts of a single nation. So this bill is trying to make set Minnesota apart, set Minnesota above the other states in the union, set Minnesota above the U.S. Constitution, and we simply can't do that. It also undermines the Uniform Child Custody Jurisdiction Enforcement Act, which has been enacted in every state except for Massachusetts. The purpose of that uniform law across different states is to prevent parental kidnapping and promote uniform jurisdiction and enforcement provisions in interstate child custody and visitation cases. This bill is, again, telling all of those other states that Minnesota doesn't want to follow the same law that all the other states are following. It's trying to put Minnesota above the law. It's trying to put Minnesota above the U.S. Constitution. It prohibits our state from recognizing out-of-state subpoenas. It tries to amend our extradition statutes to exclude acts involving what it calls gender-affirming health care. And simply put, it's a violation of our oath to uphold the U.S. Constitution to pass this legislation. It creates a huge legal mess. It's going to create legal challenges, and unfortunately, it's going to put vulnerable kids in the middle of those those legal challenges.
In summary, we want to protect the kids and ensure that every child is able to receive the help, love, and support they need to flourish in life. This bill is not the way to do that. In this time of extreme divisiveness, I want to leave you with a parting quote from Jamie Reed, who is a whistleblower, who sounded the alarm, one of the people that has sounded the alarm on the dangers of the transgender medical treatment that is going on across our state right now, or across our state, country, and the world. She's a self-identified queer woman who initially believed she was helping gender dysphoric kids as a caseworker for 4 years at St. Louis Children's Hospital. And this is her quote: "The safety of children should not be a matter of our culture wars. Let's protect our kids." And with that, we'll take questions.
Minnesota providers who offer gender-affirming care say that they have serious concerns about not putting these protections in place that would help families who are coming from other states. I'm curious what your thoughts are about that, if you see things differently.
So are you talking about providers and healthcare providers? Okay. Well, first of all, I want to point out that there's a definition in this bill of what gender-affirming care is. And this bill never went to the health committees, which is concerning. We asked for that to happen, and that did not happen. So if the providers are asking for this, they haven't knocked on my door, and I don't know if anybody here can say that that's happened with them, but I've not heard that at all.
To the point about parental rights, there were some people earlier who were talking about how, other states that are seeking to restrict access or ban access to this care, that's impeding on their decision as parents to do what they see as best for their child. What do you say to that?
Well, I guess they can already go to California. They passed this bill. And what we're here standing before you today to do is to protect the kids of the state of Minnesota. And we don't think this is the right way to do it, when you're taking away the parent from that equation in the state of Minnesota.
Could you walk us through like a possible scenario or a case in point of how that would happen, like the disrupting the parent's authority?
Yeah, so I want to address that question, the question before it, because the bill that we have before us is not limited to situations in which both parents want their child to get what this is, what is considered gender affirming care. It's very, very broadly worded and actually takes parents out of the equation altogether in a lot of scenarios. So there are a couple of concerning scenarios. One might involve a dispute between two parents in another state. Perhaps there's reasons why one particular parent would be unfit in a lot of ways, but if that parent and the child decide they want a leg up in that custody dispute, they could come to Minnesota and utilize the provisions of this statute. But even if the child is in Minnesota without a parent, there are scenarios in which this bill requires Minnesota courts to take jurisdiction over that child's case, even if both parents are in Alaska, for example, and would not support what this bill calls gender affirming health care, or the bill is very, very, very much more broadly worded than the kind of scenarios the advocates want to focus on, and it creates a lot of opportunities for some pretty serious abuses.
Has California done that? Have we heard cases where California has basically ignored subpoenas from other states?
Yes, there's some documentation about that.
All right, thank you.
Nice job.